Here we're talking about the agency relationship. An agency relationship is one in which the principal grants authority to the agent to act on his or her behalf and subject to his or her control. The reason the agency relationship is important is that it affects liability because the principal can be liable for the actions of his or her agent. An example of the principal-agent relationship would be a CEO would be considered an agent of a company or corporation. An employee would be considered an agent of the employer. And then in a non-business context, someone to whom you have given power of attorney would be considered to be your agent. The agency relationship is a fiduciary one. That means it's one of trust and confidence, and so the agent and principal should be able to trust and rely on each other. Along that line, there are certain duties that the agent has to live up to. One is performance, the idea that the agent will perform his or her duties with reasonable skill, just the same way he would as if he were doing it for himself. The second duty is notification. He's got to keep the principal informed of how things are going. The third duty of the agent is loyalty, so the agent has to be loyal to the principal. He can't go out and engage in some business that is profitable to him but would be harmful or take away from the principal, because that would be unloyal. The agent has to be obedient and do what is asked of him, and the agent has to be able to provide an accounting, meaning he has to account for any property or assets that have been entrusted to him by the principal. Similarly, the principal owes some duties to the agent. It could be that it's a relationship where compensation is required, and if that's part of it, the principal would be expected to compensate. The principal is expected to reimburse or indemnify the agent for any out-of-pocket expenses or liability that the agent incurs while acting on the principal's behalf. The principal is expected to provide safe working conditions and also to cooperate with the agent. One question that can come up is whether someone is an agent or an independent contractor. Why does it matter? Well, an employee is usually an agent of the employer, whereas an independent contractor is someone who is hired to perform a task but not really under the direct control of the employer. It's important because it makes a distinction as far as how much control the employer has. It affects whether the employer would be liable. The employer is going to have to withhold certain taxes on the employee, but not on an independent contractor. And then there are different regulations that apply. And so this makes a big difference to the employer. Here are the factors that would be used to determine whether someone is an employee or an independent contractor. First, does the employer exercise significant control over the detail of the work? If significant control is exercised, then the person is more likely an employee. Is the person engaged in a distinct line of work from the employer? If so, then the person is more likely an independent contractor. Does the worker have a high degree of skill? Are they a specialist? If so, then it increases the likelihood that they would be considered an independent contractor. Does the employer supply the tools of the trade, the tools that the person uses? If so, then it's more likely that the person is an employee. Is the worker employed for a long period of time or short period of time? If it's a long period of time, it's more likely that the person would be considered an employee. And then lastly, how is the worker paid? Are they paid hourly or salary? If they are, then they're more likely an employee. But if they're paid at the end of the job, then it's more likely that they're an independent contractor. So those are the factors that one would look at to make that determination of whether someone is an employee or an independent contractor. One thing that does not matter is what the firm or business calls the worker. You could call someone an independent contractor, but if these factors are explored and would indicate that the person is in fact an employee, then they should be treated as an employee. So how does the agency relationship come about? How is it created? It can be created by an oral or written agreement. It can be created by ratification, where the principal approves a act that really was unauthorized. It can be created by appearance, and this is also called agency by estoppel. That's a situation where, due to the action or inaction of the principal, an innocent third party is led to believe that there is, in fact, an agency relationship. So we allow this agency by appearance or by estoppel really to protect that innocent third party, because the principal is in the best place to step up and say, hey, no, this person is not authorized to act as my agent. And then the last way that an agency relationship might be created is by operation of law. Think of spouses. They can typically do things for each other. And then if there's an emergency situation, I think the text gives the example of a train engineer who's involved in an accident. He would have emergency authority to request medical attention for the passengers that were injured in the wreck. Types of authority. There can be express authority that is given orally or in writing, and along with that express authority goes implied authority, which is authority necessary to carry out that express authority. For instance, if I expressly, in a written agreement, hired you to be my real estate agent, then you would have implied authority to do the things necessary to sell my house, to put it in a homes magazine, to post it on, to show the home to potential buyers. You would have implied authority to do all those things because it's necessary to carry out the express authority of selling my home. The third type of authority that we might have is apparent authority, again where the principal, by word or action, causes another to reasonably believe that the agent has authority. And then the last type of authority is ratification, where again the principal approves of a previously unauthorized act by the agent. One special situation that can come up in the employer-employee relationship is that of respondeat superior. Let the master respond is literally what the phrase means. The general rule is that the principal is liable for the agent's wrongful acts committed within the course and scope of employment. Similar to strict liability, the idea being that employers are in a better position to prevent, bear, and guard against the loss. That's why, they do background checks, fingerprinting, and they check references and things like that. So the key factors that we want to look at in determining whether the employer or principal is going to be liable is, number one, was the act authorized? Number two, where did it take place? Number three, when did it take place? And number four, whose interests were being served? And so we would have to weigh those factors to determine whether the employer would have any liability. Some specific situations that can arise. First is the going and coming rule. The general rule there is that the principal is not liable for the agent's accident coming and going to work. So if you crash into someone during your commute, your employer is not going to be responsible for that. Second situation is the idea of detour versus frolic. A principal is not liable for if the agent's act was a substantial departure from the principal's business. This kind of goes back to the concept on the prior slide of whose interests were being served and when and where did the act take place. If it was a substantial departure from the principal's business, then the agent would not be liable. Just to illustrate this, if I were driving a delivery truck for an employer and I got hungry and I went 30 minutes out of my way to stop at my favorite restaurant, and then while backing out of the restaurant parking lot crashed into someone, well, that's probably a frolic. That's a pretty substantial departure from the principal's business, and so the principal or employer may avoid liability in that situation. But the outcome may be different if I'd stopped at a McDonald's that was along the delivery route. As far as negligent acts, the principal can be liable if the agent commits the negligent act within the course and scope of employment. But as far as intentional torts and crimes, the principal is generally not liable for an intentional tort or a criminal act by the agent unless the principal was somehow involved in it or authorized it. The last specific situation to mention is the undisclosed principal. Sometimes the agent will go out and act as a principal without telling people who he is acting for. And in that situation, the agent is going to be personally liable and may seek indemnification from the principal. How does the agency relationship terminate? It can terminate by mutual agreement of the parties. Maybe they've completed what they set out to complete and they agree to terminate the relationship. But there can also be times where the relationship may be wrongfully terminated, and if that occurs, there may be some damages that can be pursued by the non-terminating party. The agency relationship can also terminate by operation of law through death or insanity of one of the parties. Or if the purpose of the agency relationship becomes an impossibility, or if there are significantly changed circumstances, or if one of the parties files bankruptcy, or if the parties' countries happen to go to war against each other. Notice of termination is important to these innocent third parties because the agent's actual or express authority ends when the principal revokes it, but the agent's apparent authority is going to continue. And it's going to continue until that third party receives notice of termination. Until it receives that notice of termination, it can assume that the agency relationship still exists. So the principal would continue to be bound by the agent's actions until that innocent third party is properly notified. And so this protects that innocent third party because the principal is in the best situation to avoid all of this by just notifying everyone, hey, this agency relationship has ended.